Good morning, everyone. Welcome to the Ninth Circuit and today's oral arguments. I'm Judge Sanchez, and with me are Judge McEwen and Judge Paez, and we have a few cases on calendar with one submission, United States versus Joan Bailey et al. And the first case we're going to hear argument on is Zoe Hollis versus R&R Restaurants, Inc., case number 24-2464. I want to remind counsel that we've closely read your briefs and are very familiar with the arguments, so please confine yourselves to the most pertinent points. And if you want to request time for rebuttal, please let us know in advance. Counsel, you may begin.
If it may please the court, John Christensen on behalf of the appellant, and I'd like to reserve 5 minutes, Your Honors, if I can. And thank you so much for allowing me to appear remotely while I'm in treatment. It made things very easy and helpful for my family. And with Your Honor's statement that you want me to keep things brief and to the point, and I reviewed the briefs in preparation for today, and there's one point that I think maybe wasn't directly addressed, but is brought up everywhere. The statute itself says 15A3 is a violation for any person to discharge or in any other manner discriminate against any employee. And in Arias, the analysis was who is any person. Here, the real analysis for this court is going to be any employee. And we think that the district court failed to take that into account because the district court and the magistrate never analyzed whether or not the appellant was an employee of Sassy's, only of the place where she was retaliated against, which was at Dante's.
So, can I ask you a question? Just
Absolutely.
Something that caught my attention as I was reading over the material. And the cases, there's a case called Arias versus Raimundo.
Correct.
Right? And the magistrate judge cited it, but didn't really give it much credence as applied to this case.
I tend to agree with you, Your Honor.
The magistrate judge said, well, there was an employment relationship in that case, and so we don't have to. Doesn't really help here. It doesn't really make any difference.
I don't think that helps.
So let me just ask you this: Is there more? Isn't there more to Raimundo or to Arias than the magistrate judge gave it?
There's absolutely is, and I appreciate that, Your Honor. Arias extended the any person to lawyers for a defendant, saying any person can retaliate against somebody who makes a claim. And in that case, it was pretty clear that any person, the lawyer, by tipping off ICE to deport somebody, was retaliating against somebody for making a claim regarding their employment condition.
Now, there had been an employment relationship, right? At one time there was.
There was. And in our case, there was a employment relationship between Hollis and Sassy's.
So let me ask you that the problem I have, not the problem, but the interpretive issue, it seems to me, I don't have any problem with any person because Mr. Falacio or whatever his name is, he's a person and he qualifies. But the question is, she was retaliated against at Dante's, not Sassy, correct?
Correct.
Okay.
And
so how with respect to the statute, she's discharged or retaliated against as an, quote, employee of Dante? Is that right or no?
Not as an employee, as a former employee of Sassy's. And the specific term in the statute says any employee. That means past employee. And you got to go back and look at the Arias decision where the court took an analysis from the U.S. Supreme Court in a Title VII case, which we do for interpretations of FLSA cases. And they did an analysis and they looked at it and they said that for these reasons, we conclude that the Title VII substantive provisions and its anti-retaliation provisions are not coterminous. The scope of the anti-retaliation provisions extend beyond workplace-related or employment-related retaliatory acts and harms. So here, if it's a former employee and they're being retaliated afterwards, then they still have a claim.
Let me ask, let's say that we have somebody from Starbucks, that's any person, and somebody waltzes in to get a job, and the Starbucks person finds out, oh my God, this lady's filed one or two of these kind of FSLA or other kind of suits. I'm not going to hire her because I don't really like having potentially disruptive employees. Would that be covered by the statute?
It would, and good luck proving the correlation and causation in that case. You're not going to be able to find it. That's why you don't have those cases percolating and coming up.
I was going to ask, what about the fact that in Arias there was also a pending FSLA claim against the Angelo Dairy employer, whereas here the claim was dismissed as time barred against Sassy's. Does there need to be a pending claim against the employer for the retaliation claim to go forward?
No. And then you're going to get in concerns, because then it's going to be a question of whether the only people that can bring a retaliation claim would necessarily be in the circumstance like my client, where her underlying claim, while she didn't win on it, it had merit when the issue came to the willfulness aspect and the extension of the statute of limitations from 2 to 3 years. If you're going to get to the point where you're saying, well, you have to be contemporaneous and other FLSA claim to bring the retaliation claim, you're going to limit the scope of the retaliation statute, and they're two different animals, as the Ninth Circuit explained in Arias.
So let me see if I really understand your claim, or her claim. Fallis was an owner of, part of the ownership group of Sassy's, is that right?
That is correct.
And she claims that in her misclassification suit that she was actually an employee, not an independent contractor, of Sassy's. Is that right?
That is correct, Your Honor.
And she alleges that Felice, is that how you say it? I'm not sure how you say it. That he was the owner of Sassy's. Of Dante's. Is that right?
Correct.
And that
He is the owner of both.
And that she had, so therefore, that as I understand it, that's the connection, is that when she then sued for the misclassification, she alleges that Fallis retaliated against her by terminating her contract at Sassy's. Is that right? Is that the whole theory?
Terminating her contract at Dante's.
At Dante's, I'm sorry. I keep getting them confused, but at Dante's, yes. Is that the whole? Is that?
Yeah, he admitted it too, and it's in writing.
No, but is that the whole structure of your claim?
Yes.
Well, let me follow up on Judge McEwen's hypothetical about the Starbucks example, because as I read the statute, it seems, or at least as when I read Arias, it seems to also require that the retaliator is acting in the interest of the employer. So there's some connection between the person who's doing the retaliating and the employer that the FLSA claim is against. So at least for the Starbucks example, that unless there's a connection to someone, that wouldn't be enough to file a claim for retaliation. But I take it here you're saying that the defendant Felice is connected because he was a partner with Sassy's. Is that right?
Yes, and the claim was against him. So he was a member of Sassy's, and he specifically said, "I am one of the partners in Sassy's."
And
do you retaliating against her?
And do you agree that there also has to be some connection that the retaliator is acting in the interest of the employer?
I think that when it says any person, if someone wants to retaliate against somebody for something else, I don't know if it's limited to that. You're going to have a hard time finding somebody and having a hard time proving causation in those circumstances. And I don't think it's necessarily limited to that.
Well, that we've focused on the definition of employee, but the definition in the statute of employer includes any person acting directly or indirectly in the interest of an employer. So in that case, if you look at the definition of the statute, is Felice acting both in the interest of an employer at Dante and at Sassy?
I think you can absolutely make that sense, because what he's doing is he's further serving as a deterrent to anybody else to make that type of a claim. If you do this, you're not going to be able to work in any other clubs in town. And that would serve as a deterrent and to discourage people from making those types of claims.
But the claim, as I read the statute under subsection 3, the claim that an employee filed doesn't have to relate to that person's status as an employee where the person was discriminated against or discharged, right?
Correct.
So in that case, again, if you're an employer and you see an employee who's a filer and you won't hire them or discharge them, it doesn't matter that their complaint made previously had nothing to do with your business. Is that right? Or do you have to have a nexus?
Well, I have the nexus.
No, that's
case.
not the question.
But do you have to have the nexus? I think there's still, you're going to still need to show the but-for causation. In a case, you're going to have, they made a claim that they were retaliated against in some circumstance, and also that it was because they made the claim. You're going to have to show that. That's part of any retaliation.
Well, it says because they filed any complaint. It doesn't say any complaint against that employer or any complaint against anybody in particular.
I think you're adding more fuel to my argument. And
I'm not adding anything. I'm trying to interpret the statute.
Well, I appreciate it. I don't mean to be putting any words in your mouth, Judge McCain. Let me back up in one essence. Because I think the magistrate's ruling kind of ignores a lot of it, and it helps. And I try to bring this up. And it also it's consistent with the analysis of the Supreme Court in Burlington, which we should be considering, and which said it doesn't have to be a workplace related retaliation. If a former employee makes a claim against their old place, I don't work there anymore, but you didn't pay me overtime. And then they go and send somebody, one of the owners comes in and kneecaps them, does a galooly, like in the Tanya Harding circumstance. And that person gets their knee hit. That's still retaliation. We hit you in the knee because you sued us for overtime. And here, the circumstance here is he didn't hit her in the knee, but he still took a contract away from her, still precluded her from making money somewhere else. And the statute, the anti-retaliatory statute in a remedial situation is meant to preclude these types of actions. How many of the cases are there going to be where somebody sues a former employee? It's not limited to just current employees, and it's any type of complaint. Just like the court said, and it's any employee. It's a broad statute.
Yeah, I don't think you need to kneecap, obviously, to discriminate or to discharge. But if she goes to another dance club, not the Dante Dance Club, and she applies for a job, these guys are friends of Felice and buddies, and they say, well, I'm not, Felice here was very honest as to why she wasn't being hired. And these guys are equally clueless on what one might say and say, I'm not going to hire you because you sued that other dance club. would she have a claim against the new employer or the prospective employer?
Yeah, if they said that out loud. That would show the element that I need to show, which is at issue is the retaliation element.
But she doesn't, so that comes back, though, to interpreting the statute. Under that scenario, there doesn't need to be any nexus between the complaint she filed and the new people, or the new employer, right? It's just any complaint.
That'd be in a hypothetical that we don't have here.
I understand that. Otherwise, it wouldn't be a hypothetical.
Yeah, and well, I think that's relevant here because I do have one of the partners at Sassy's who retaliated. And I'm not asking the court to, I'm not saying the district court, which didn't make that statement, didn't do that.
Wait, could I just follow up on
and it's a good question.
It's a good question, but your answer is not quite
Precise.
Yes, not
But it's
quite
not
precise.
strict.
Let me just follow up on, add a little further twist to Judge McEwen's question. So in Judge McEwen's question, she posited a situation where Ms. Hollis just goes to some other club and they say, hey, we're not going to hire you because you sued Sassy's for misclassification, and we don't want you here. Would she have to prove that they did that in furtherance of the interest of Sassy's? I mean, what if they just, was in the community? They just knew that, there was this lawsuit and Ms. Hollis was the one who filed it. Do they have to prove? Would she have to prove? Would she have to prove that they were that when they wouldn't hire, that they were doing that to further the interest of Dante's, where she was an employee?
I don't think the statute says that. I don't.
So the answer to Judge McEwen's question should have been yes, Judge McEwen. You're right.
You're correct, Your Honor. And that's why you got to go on the bench, and I'm here in this office.
I guess we're going to take you over a little bit because I need to follow up with that. Arias was about the employer's lawyer retaliating against the plaintiff there, calling ICE and arranging for things. And so clearly that lawyer was never an employer of the plaintiff. But Arias does talk about, and the statute defines an employer or defines an employer to include any person acting directly or indirectly in the interest of an employer in relation to an employee. That's the hook for creating a private right of action to go against someone who's retaliating against. So if you don't think that there needs to be a connection to or acting in furtherance of the interest of the employer, what is your statutory hook for your argument that it doesn't have to be that way?
Well, I do have that because Falius.
No, but it's not whether you have it or not. I think we're trying to understand what the appropriate rule of decision should be in interpreting the statute. And so you may have it, but just is that a requirement for a retaliation claim is what I'm getting at.
I think it's inherent in the retaliation that it has to be because this question of what's your retaliation? Is it to send a message for you mess with my old club, or I'm not going to let you do anything like that in the future?
So in this case, if we were to determine that the statute has been incorrectly interpreted and it would need to go back, would your client need to, in effect, litigate the Hollis versus Sassy suit as to whether she's an employee or an independent contractor? And that is a suit. And that is actually a suit that's now been time barred. So would she be litigating the underlying facts of a time barred lawsuit?
That goes back to the question whether I need to prove the underlying FLSA claim. And as long as it has merit, when you bring the complaint, you can be retaliated against.
No, but she has to be an employee of someone, and so.
Yeah,
And who is she an employee of?
she was an employee of Sassy's and Mr. Falas.
Okay, so, but then she would have to, I'm just trying to understand if it goes back, the district judge can say, now what? So does she then have to prove that she was an employee? Because there's obviously a dispute about that.
Yeah, and the magistrate avoided that entire argument. And I produced...
No, my question is actually pretty simple. It's more of a procedural one.
Yes, we can go back.
What do you have to prove if you go back?
Well, we have to show that she's an employee of somewhere, and
that somewhere
she was retaliated against by someone for making her claim, the underlying claim.
So she would have to prove, and you keep saying the employment relationship is with Sassy, so she would be having to prove a claim that has been time barred in effect, right?
No, not necessarily. It's part of it, whether it's actionable is correct, but that's for the willfulness. But she still has to prove that she's an employee.
Right. You just wouldn't be asking for any damages for wrongful misclassification.
Correct. The whole
You'd classify her one way or the other in the district court. You'd come to a resolution, right?
Yeah, and I'd like to, I think the evidence was absolutely overwhelming that she was an employee.
Okay, well, I think we've heard quite a bit. Let's hear from R&R Restaurants, and we'll give you a little bit of time for rebuttal.
Thank you.
You may be muted.
Unmute. Good morning, Your Honors. May it please the court. My name is Anthony Kachulis, and I will be arguing on behalf of the respondent, Falaci. Based on the court's points from the exchange that just occurred, it seems like there's two big issues here. One, whether plaintiff can bring claims of retaliation under 215 if they cannot establish employment status of any kind. Plaintiff's preferred pronouns were they, them, so I'm going to use that as best I can. If I slip, it's apologies. So under the court correctly identified that under 215, the plaintiff must establish an employment relationship with someone somewhere at some time. The claim that Sassy's misclassified plaintiff is time barred, and our position is that plaintiff cannot go back and relitigate that for the discrete issue of whether it was retaliation. We supported that argument with Allred v. City of Granada, which related to plaintiff's claims that they had been coerced into signing an unlawful FLSA agreement with the employer. That claim, even though they continue to be paid less than under that agreement, could not be relitigated because the court would not go back and reopen that issue of the coercion, even though it might have related to some later damages or remedy available.
But how do you get around Arias? Because we were very clear that you can file a retaliation claim against someone who is not and has never been an employer of the plaintiff, right? This was a lawyer who was acting at the behest of the employer. And it seems to me, at least, that the magistrate judge didn't really grapple with that in deciding that because appellant was not an employee of Dante's, that closed everything off. That seems wrong to me.
Thank you, Your Honor. Arias is very distinguishable. We believe the district court correctly held that even under Arias, there has to be some employment relationship established for there to be a recovery. No employment relationship with Sassy's was established by plaintiff. And plaintiff seeks to strip Arias of all of its limiting principles, frankly. The undisputed facts were that...
But the magistrate never engaged in an analysis of whether appellant was an employee of Sassy's. If we were to send this back and appellant is able to establish that they were an employee of Sassy's, Wouldn't that fit into the Arias framework of allowing a retaliation claim?
It was, Your Honor, it was brought up during the last argument that it still would not, based on the fact that Mr. Falacci was not acting as an agent of Sassy's with respect to making a legitimate business decision for who could do a one-off performance at a variety show at a bar called Dante's. Arias had been employed by Angelo Derry. That was established. But also, it was more clearly established that the attorney was acting as the Derry's agent. Mr. Falacci's email, frankly, is well put and sets forth the legitimate business reasons that, under McDonnell Douglas, should be considered as an alternative basis for supporting the district court's decision that it was a business decision to not have them perform.
That seems at least to be a tribal question. The email directly mentions that he's a partner at Sassy's and that he received the class action complaint, and then he goes and pulls back the contract. So there's at least a tribal dispute whether he was doing this in the interest of Sassy's, isn't there? I mean, be careful what you write when you go against what your lawyers tell you to do. I suppose might be one takeaway from this.
Fair enough. So the legitimate business interest of Mr. Falacci in holding on plaintiff performing this one-off until some clarity was came forth about whether they thought they were a contractor or an employee is very importantly distinguishable because there's been no response by plaintiff either before the trial court level or here in the reply brief on appeal that suggests how Mr. Falacci's perspective was somehow pretextual or not legitimate or not for the reasons that he stated. Plaintiff's status as whether or not they were a contractor or employee at Dante's or whether they thought they were a contractor or employee really hasn't been clear until today, when it seems that plaintiff is now, conceding that Dante's was clearly a contract relationship. Based on that ambiguity, Mr. Falacci there's been no evidence to suggest that Mr. Falacci was acting with some sort of ulterior basis. And under the McDonnell Douglas test, that would mean that plaintiff's claims would fail on that alternative basis as well.
So the question then is, the record isn't very well developed as to all these relationships. So would there be a factual issue on that at this stage?
Your Honor, the record is well developed, we believe, with respect to defendants' positions and defendants' arguments. You are correct that it's not well developed with respect to plaintiff's positions, and that has to do with, that's outlined in detail in our procedural history in our brief. Plaintiff failed to make discovery over the course of over a year with extensions and a whole lot of leeway being given by the court. The court was quite exasperated by their failure to do so, and after our summary judgment motion was held for, I think it was a year, maybe over a year, the court finally decided that enough was enough and it needed to make a decision based on the record as it existed. So we believe the court was well within its discretion to make that decision. Therefore, the record as it exists, may not be sufficient for plaintiff to fail because we don't believe that there's any evidence to support that. But any failing of the evidence or, we would have proven this if we'd had more time argument should also fail because plaintiff did have more time, had the chance to make that argument and simply failed to do so through their own inaction.
May I ask you what your interpretation of the statute is? I think you would have to agree that Mr. Felice is any person. He's a person, right?
He is a person.
So we got something established. But does that person need to have the employer-employee relationship with an employee under Section Sub 3 of the statute? If you discharge and discriminate against an employee. So in other words, in your view, does his relationship need to be between him and her at Dante's or at Sassy's, or could it be both?
That's a good question, Your Honor. The way we understand that statute is similar to how the court interpreted it in the Arias case, which is that there has to be an employment relationship somewhere, and the person who's being accused of retaliation must have been acting, clearly on behalf of the employer who is alleged to have done the wrong act. Here, Mr. Fallaci was not acting on Sassy's behalf. There's no credible fact to support that this was some sort of a later, arbitrary or kind of punitive measure. In fact, really important, plaintiff had other contracts with Mr. Fallaci for presenting workplace culture trainings that were quite a bit more lucrative than this one-off $50 performance. Those contracts were retained.
I wanted to ask you about that as to how that figured in fact, that she could do these training videos, but she couldn't participate in this one kind of dance performance, right?
Yeah, Your Honor. That supports the position that Mr. Fallaci was not acting as an agent of Sassy's to punish plaintiff for bringing claims, but rather as very clearly a legitimate business person looking out for Dante's and trying to understand what plaintiff's position was when they danced, whether they considered a single song dance performance contract or employee status. Now that was up in the air based on plaintiff's claims and frankly position.
Could you articulate why it is that Felice wouldn't let her perform? What did he say?
Well, the email is quite clear, and as I recall it, he said that the lawsuit against Sassy's brought into question whether plaintiff believed that they performed as a contractor or an employee for their one-off occasional performances at Dante's, as both of them involved dancing. Now, they were very different types of dancing. Dante's was like a burlesque variety show. Sassy's is a strip club. But the reason was, frankly, the law is just not terribly clear and easy for lawyers and judges to apply with economic realities.
But the reality is that he, in effect, discharges or limits her role in dancing because she had filed a lawsuit over, am I a contractor or an independent or an employee, right? I mean, that's what's so odd here is that he's more honest than most, and you actually see in the email that the lawsuit is the reason she doesn't get to perform these other functions at Dante's. And that's because under the statute, she's filed a complaint or instituted a proceeding under this chapter. So
the
question is, does she have to be employee of Dante for that, or does she have to be employee of Sassy?
I think that they would have to be well, here's the important thing, is that this actually came up in Arias when Arias was distinguished Dillinger v. Science Applications. And the court expressly held that there's no liability for retaliation for not hiring a prospective worker under the FLSA. That's the same situation we have here with respect to Dante's. Our position is that plaintiff would have to establish an employment relationship at Sassy's, and that Mr. Fallaci would have had to present evidence suggesting that his decision to not have them perform one song at a variety show related to an effort to chill or punish or deter the types of claims that plaintiff was bringing. The cultural workplace trainings are important on that, because if Mr. Fallaci's intent was to chill plaintiffs, or to punish plaintiff for bringing claims against Sassy's, obviously those trainings would not have continued. It shows a very...
Let me ask you, was she, vis-a-vis the trainings, was she an employee or an independent contractor?
Hollis was a contractor, and I think that the understanding was that... Okay,
let's just stop there. She's a contractor vis-a-vis the training videos.
Correct.
Is her status as a dancer that of a prospective employee, and therefore, under your position, wouldn't be covered at all anyway?
That would be our position, Your Honor, yes. That's an alternative basis for upholding the district court's decision, correct?
But I mean, presumably under Arias, whether or not she was a contractor at Dante's, we'll use the right pronouns, if they believe that they were an employer at Sassy's and that Mr. Felice did something because of the lawsuit that they had filed, why would that defeat a separate thing about prospective employment? I'm not sure I understand that point.
Sure, Your Honor. So our understanding is that real quick, so I can understand the question. Sorry. Are you saying you're presuming that?
Well, let's say Hollis establishes that they actually were an employee of Sassy's, and then it gets to a tribal issue as to what motivated Mr. Felice from withdrawing the contract, whether it was in retaliation or for some completely independent basis. Whether or not Hollis would also potentially be a prospective employee or something at Dante's shouldn't make a difference one way or the other. It shouldn't stop the retaliation lawsuit from happening, as I understand it.
Your Honor, our understanding is different, is that even if plaintiff was an employee of Sassy's, that the loss of potential prospective work at Dante's would not constitute retaliation unless Mr. Falaci was acting as an agent of Sassy's and acting with a retaliatory motive. I think the really important thing here, again, going back to the record, is that there's no evidence whatsoever in this case to support an argument that Mr. Falaci was not acting for the reasons he stated in the email.
Okay. Let me ask you one last question before, your time's running out. Does it matter in your view whether there is a pending FLSA claim or just one that had been filed in the past? Should that affect a retaliation claim at all, one way or the other?
Your Honor, I haven't briefed that specific issue, and I'm not aware of any limitation regarding whether it's pending or not. But frankly, that's not something that we saw it as an issue here.
Okay. Thank you. Thank you for candor. Let me see if my panel has anything. Thank you. All right. Mr. Christensen, we'll give you a couple minutes for rebuttal.
Sure. And I think I kind of want to get back to a point I made earlier in the Arias analysis. The Arias analysis fits these circumstances because they adopted the Title VII analysis for an FLSA case, and they specifically cited that the retaliation can be from a third. The retaliation can be beyond workplace retaliated relation, extends beyond workplace related or employment related retaliatory acts or harms. There was sufficient evidence here to show that the retaliation was due to her filing the lawsuit in Sassy's. And in this analysis, it's all the evidence is taken in the light most favorable to my client. And so I think if you look at the breakdown, we're not asking the court to extend anything further. The district court didn't do those analyses. The district court focused pretty much exclusively on whether or not she was an employee of Dante's and ignored whether she was an employee of Sassy's. And we think it should go back. There's additional evidence that perhaps wasn't in the record that shows that this retaliation was on top of it. Subsequently, Sassy's, through Mr. Felice, sued in state court for defamation related to this case. And that case has been beat back, but that's further evidence showing that the acts at Dante's were retaliatory in nature. There's facts that show that in the record. His email shows it. You can read it in my client's favor saying, hey, you filed a lawsuit. I'm not giving you work.
Great. We're done. Thank you. Counsel, thank you both for your helpful arguments. The matter will stand submitted.
Thank you.
Thank you, Your Honors.